Good afternoon, everyone, and welcome to this TUC seminar on data protection and information security. I'm Emma Hakwsworth. I'm a solicitor from Slater and Gordon, and I've been asked by the TUC to talk about data protection and information security. Please join in and participate during this webinar. If you look below the video stream, you'll see questions and polls, links which you can click on. And if you have any questions you'd like me to answer, please submit them and I'll do my best to answer as many as possible at the end. You've also got a chat area to the right. Do say hello and chat to the other participants, although don't include questions for me there as I won't see them. So what's today all about? As a workplace rep, you handle personal information about members all the time. For example, member contact details, personal case correspondence and documents, membership lists. And it's important that you protect that information and keep it secure. There's some new law in this area, the General Data Protection Regulation, or the GDPR, which is coming into force very soon on the 25th of May 2018. It's got significant implications for organisations who handle personal data, including unions and union reps. So what's changing? Well, our current data protection laws date back to 1998, and these haven't kept pace with advances in technology and the way we use data now. In 2016, the EU Parliament approved new data protection rules which are contained in the GDPR, and overall they're intended to give people better protection of their privacy rights and information. There are some enhanced protections for individuals, such as stronger subject access rights, and some new rights for the digital age, such as the right to be forgotten. You may have read about a legal case brought by individuals who wanted Google to delete some old results which came up on their name when searched, which they argued didn't comply with their right to privacy. The right to be forgotten looks likely to be an important part of individual privacy rights in our increasingly digital world. And so with the GDPR bringing in these new rules, your union head office will be making some changes, and you may see more detailed membership applications or more information on privacy notices on the union website. And your union may have appointed a data protection officer or DPO to oversee all of these changes. In today's session, I'm going to start with a brief introduction to explain when the data protection rules apply, and then I'll highlight three main topics. First of all, some initial steps that you can take to prepare for the GDPR, then a focus on how you keep member information secure, and finally, a word on respecting members' rights. It's important to say that this is an introduction only because it's a vast subject. And the intention today is to highlight these aspects for you to think about, take them away and look into them further. And of course, this isn't intended to be formal legal advice. It's just a guide to some important overview points. So let's get started. First of all, when do data protection rules apply and what information is covered? Well, the data protection rules apply to any information about a living individual from which that individual can be identified. So that includes obvious things like name, date of birth, address, and less obvious things like IP address or email address. And the GDPR refers to all of this as personal data. In some cases, the individual will be easily identifiable where their name's included, for example, but the rules still apply even if the individual is not identified by name, provided they're identifiable by some other feature, such as, for example, their union membership number. And some categories of data have stricter rules and are referred to as special categories of data. This is also known as sensitive personal data. The special categories of data include information about an individual's trade union membership, health, politics, race, religion, and you need to be particularly careful when handling special categories of data. So that explains what information is covered, and next we need to look at what activities are covered by the rules. The GDPR refers to processing of data, which sounds like quite a technical exercise, but in fact refers to pretty much any use of data, including copying, reading, sending by email, as well as storing information or deleting it, All of these count as processing, and so the rules apply to all of those activities. And this covers work on a computer or any electronic device, like creating documents or sending emails, but it also covers paper records as long as they're in a filing system, like personal case files, and any paper documents waiting to go into a hard copy or an electronic filing system. So here are some examples of when your handling of member information will count as processing personal data, which means the rules apply. So accessing or working on a membership database on a computer, or personal case files in a cabinet, reading a grievance outcome which has been emailed to you by a member, taking handwritten notes in a meeting with a member, provided you intend to put those onto the member's file, looking through contact details on your mobile phone or laptop, will all amount to processing personal data and will need compliance with the rules. One type of information to which the rules may not apply is handwritten notes which aren't intended to go into a file. So that would include, for example, jotting notes down in your diary, which you don't intend to move into any kind of filing system. But you'll see from this list that the data protection rules are likely to apply to almost all information that you handle as a workplace rep, especially member information. And in fact, almost all personal information about members that you handle as a workplace rep is likely to be special category data because it relates to trade union membership, and so the stricter rules will apply, and you should take extra care when handling it. So I'm going to move on now to the 3 topics I want to cover today in a bit more detail. The first of these is what you can do to prepare for the GDPR. The first step is to find out from your regional or full-time officer what your union's data protection and information securities are. Read them, get familiar with them, and make sure that you follow them when you handle member information. Also, you should be aware of what the GDPR calls the data protection principles. These are really the golden rules for handling personal information. I'm going to go through a short summary of the key principles on those now. So first of all, the GDPR requires that you handle data fairly. This means you should only use member information in line with your union's policies. In particular, don't share it with any third parties. And remember that membership lists are special category data, so take extra care with this information. You may have heard a lot of conversation about GDPR around the issue of whether you need to get consent. Consent is one condition for processing personal data, but it's not the only basis on which unions can process personal information about members. For most day-to-day activities by unions and reps, unions will be able to rely on what is known as the legitimate activities condition. There may be some circumstances where consent is required, particularly where you're dealing with non-members. So, for example, when running campaigns or events that involve non-union members as well as members. Your union will be developing policies, so you will be aware if consent is needed in any situation. And even though you may not need to rely on explicit consent, it's good practice, for example, when you're talking to a member about grievance or disciplinary procedures, and particularly in relation to medical records, to make sure that members know how you'll use their information. And I'll come on to this next. The GDPR's golden rules also require you to be open and transparent when you collect information from a member. So when a member gives you any information about themselves, whether that's an email address or a bundle of documents, you should make sure that they know why you need the information and what you're going to do with it. So that might mean telling them which email address you'll use to communicate with them, or in an example where you're assisting a member with a personal case about sickness absence, if you need copies of GP letters, you need to tell them why you need the letters and what you're going to do with them. Be particularly clear about who you're going to send them to and what you'll do with them afterwards. If you do intend to give copies to the employer, check that the member understands this and is happy for you to do so. The principles also require that you don't take more personal information than is needed for the purpose. The GDPR calls this data minimization. It really means only take what you need. So in the example of the sickness absence case, if your member has a full copy of their GP records, but the latest letter's got all the up-to-date information, consider carefully whether you do need the full file or whether the latest letter's enough. And finally, on data protection principles, the GDPR requires that you keep data up to date and that you don't keep it for longer than you need it. So make sure you update your records when your member provides you with new information, like a new workplace or email or home address, and make sure that you're not sending information to the wrong place. Also, get familiar with your union's policy on how long you should keep information for. And this will vary depending on what the data is. Some issues you might want to consider include how long you keep information about old members and personal case files. So that's covered the first of the topics I'm going to deal with today about handling data fairly. I'm now going to move on to the second topic, which is about information security. This is a fundamental part of keeping membership data safe. Unions and their reps will handle all sorts of very sensitive information about members, and it's very important to keep it secure. So the Information Commissioner, known as the ICO, is the regulatory body who considers complaints about breaches of data protection and information security. This slide gives some examples of the ICO's decision on a few complaints of data breaches. Many concern hacking. Back in December, Carphone Warehouse was fined £400,000 when 3 million customer records were put at risk because the company had outdated software which it hadn't updated, and that made it vulnerable to a cyber attack. Human error is another danger area. A barrister last year was fined £1,000 when her files were all uploaded to the internet, including confidential client matters, when her husband was updating software on their shared home computer. And the ICO is very firm about passwords and encryption. The ICO criticised a lawyer whose laptop was stolen when she was having work done on her home. It contained confidential information about 8 individuals which she hadn't password protected, and the guidance is very clear that you should do. In cases of any loss or misuse of data that you become aware of, you should immediately contact your regional or full-time officer or your union's data protection officer so that they can advise you about what you need to do. Next, I'm going to highlight some areas that you might want to consider about the ways you work and how you keep your member information secure. The starting point for all of these security issues is to read your union's policies about keeping member information secure and check that the way you work is in line with them. So with paper files, for example, do you have a clear desk policy when working at home or in the workplace to prevent other people seeing personal information about members? Do you need to keep files in a locked cabinet? And take particular care when travelling. Don't leave papers or a laptop unattended, and don't discuss personal case details on public transport when others can hear. You also shouldn't leave papers or a laptop in your car, but soft copies rather than paper copies are usually safer because of the ability to password protect documents that are in digital form. Another area that you can think about is the way you use computers. Use remote access to a union system or a case management system if one is available. But if that's not available and you're using a shared computer, make sure you set up a password-protected individual user account so other users can't access your documents. And loss of electronic documents can also cause problems. So think about the arrangements you have for backing up your computers and other devices and make sure that they're safe. Some 25% of complaints to the ICO relate to loss of data on mobile devices. So make sure they are password protected. And if you're using particularly sensitive documents on a mobile device, think about adding individual documents. Finally, on information security, some issues to consider about the way you use emails. Again, check your union's policies as a starting point. With work email systems, practice may vary. In some workplaces, reps won't use a work email system for communications with members, but others may have facilities agreements permitting use of workplace emails. If you're unsure about the practice in your workplace, check with your union whether it's okay to use work email. And if you are using it, include the words private and confidential in the subject line of emails, communications with members. If you're not able to use your work email to correspond with members, you could use a union email address if you have one, rather than a home email address, especially if it's a shared family email. If you don't have a union email address, you may need to sign up for an email which is only accessible by you. Again, if you're concerned, think about password protection, particularly of sensitive documents. So in summary on information security, read and understand your union's policies and check with your regional or full-time officers if there's anything you're not sure about. And think about how you protect member data in a workplace, at home, on the move, and using mobile devices, computers and email. And report any loss or unauthorised use of member data. So the focus this far has been on data protection responsibilities of those who handle personal information. And the third topic I want to highlight today is the data protection rights of individuals. The best known of these is the right to make a subject access request. As I said earlier, the GDPR provides for stronger subject access rights. Individuals have the right to be given access to their personal information, generally without paying a fee, and in standard cases, information must be provided within a month. This applies to all organisations which handle data, including unions. So members have the right to request access to their personal data held by the union about them. There are 2 points to bear in mind about this. First of all, remember when making notes and corresponding about members that they have the right to ask for copies of what you've written about them, and they may exercise it. Secondly, if you receive a subject access request from a member, don't try to respond to it yourself. Pass the request to your regional or full-time officer and do it immediately, as there's only a limited time to respond to the request. If you're asked by the union to provide any information to assist with a response to a subject access request, for example, copies of your correspondence with the member, do so promptly. And finally, read your union's policies so that you understand the rights members have to access the information that you hold about them. So that brings us to the end of this part of the webinar, which I'll sum up in these 4 points. Firstly, check your union's policies and make sure you're applying them. Secondly, think about your use of member data, especially since the data protection rules apply to almost everything you deal with. Thirdly, keep member information secure. And finally, report any subject access requests you receive and any loss or unauthorised use of member data. Now we have a short period to answer your questions, which have been coming in during the earlier parts of the talk. I'll be joined for the questions by Hannah Reid of the TUC.
Hello, Emma. Thank you very much for that very clear overview of some of the issues that reps should be thinking about when dealing with personal data in relation to members. Now, we've had several questions coming in from individuals watching the webinar. There have been several questions that sort of relate to the same issue, so I'm just going to group those, which is about the length of time that reps and unions should keep members' information on file and different types of information. One question we were asked is, how long can and should unions keep on file financial information relating to members? For example, if a member's made an expenses claim for attendance at a union conference or something such as that, is there a generally good guides practice in terms of the retention of such information?
There are no hard and fast rules on how long you keep things, and that's deliberate. The data protection rules vary depending on the circumstances, depending on the nature of the material that's being handled and the workplace itself. So it's going to depend on a number of factors, and the starting point on this, as with much of the data protection rules, is to check your union's policies. The key issue really is how long you need to keep it for. If there are good reasons for retaining information, then it can be kept for longer. Once you no longer need to keep it, that's the point at which you ought to be thinking of deleting it.
Okay. And also on the same theme, a question was also asked, what's a reasonable union policy in relation to keeping case notes, information about cases, union members' cases?
Well, for personal cases, there is a possibility that they may be needed if there's any claims brought later on. So you normally say a minimum of 6 years for those kinds of files.
Okay, that's really helpful. A lot of questions, or some questions, have also come in about the issue of consent and when, if ever, unions will need to gain the consent of members before being able to process some of their data, or as some people actually sent in questions before your seminar asking questions about when might unions be able to rely on legitimate activities. I just wondered if you could maybe talk a little bit more about those issues.
So when processing, so using in any way special categories of data, one of the conditions which is set out in the GDPR or the data protection rules needs to be met. And the one condition that can justify processing special categories of data, such as trade union membership information, is explicit consent. And so that's the one that many people will turn to. But there's a second condition which is related to the processing of data in the context of the legitimate activities of a trade union, provided that it's data relating to members or former members. So whenever in the course of its day-to-day activities a union's processing membership data, that condition is very likely to be met, and there won't therefore be a need to rely on the explicit consent condition. It's where you're processing or dealing with information about non-members that the legitimate activities condition won't be met, and then either a different condition or the consent condition will need to be looked at.
And one sort of follow-up question about that, which relates to different types of services that unions might offer to members. So sometimes unions will offer financial services, etc. Are there any instances then when unions might need to be thinking about consent when offering financial services to members?
Well, there's going to be a spectrum of services that are provided. If they're very clearly part of legitimate activities, then the consent won't be needed. The further you go away from the legitimate activities of the union, the more likely you are to need to look for consent for the member, and that's worth considering, really. And
other questions that have come in, I'm going to group a couple of questions together, which is about different types of communication and how, with using new technology, what types of communication are covered by data protection rules. So a couple of questions are, is a text the same as an email? Is a text an SMS with a member the same as an email?
Well, it is, yes. I mean, it's an electronic communication, so the rules will apply to texts in the same way that they apply to emails.
And what about using services such as MailChimp, which are online services?
Well, in some circumstances, the processing of data on your behalf by another company falls within a set of rules called data processor rules. And that's essentially where an organisation is only dealing with data under your strict instructions. So some unions may have agreements with other organisations to process data on their behalf. But it's important that the rules relating to data processors are complied with. That includes having a written agreement in place that deals with certain matters, and also being sure that the data processor themselves has sufficient information security protections in place to avoid data being transferred to them and it not being safe.
And then there are a couple of questions that have come in about information held within the union itself. And what are the rules, for example, if a union rep contacts an officer and asks about a particular member, can the full-time officer provide information to a union rep about a particular member? And what about also, just to add in the second question, about when whether reps can hold membership lists about union members?
Well, certainly discussions between officers and union reps would be part of the legitimate activities of the union, so that would be fine. And membership lists, I'd suggest that may vary practice across different unions. So I'd suggest, again, looking at your union's policies to see what the provisions are for dealing with membership lists. But again, be very careful because it's a special category of data and you need to ensure that you keep it secure. You're only dealing with it as you should, in line with the rules, which will primarily be looking at the policies.
But is it right, Emma, that union reps are part of effectively the same organisation as union officials when it comes to data protection? So we're all part of the same body?
Absolutely.
Okay, so that's really, really helpful. And then another question which has come up, which is a really regular issue that union reps face. We often, one of our expertises and our key roles as union reps in workplaces to deal with health and safety and accident reports in the workplace, which often will include personal sensitive data or special category information. If that information needs to be passed on to an insurer to look at issues about compensation, how should a rep or an official handle such data? What type of steps should they take?
Well, although you might think that's the legitimate activities of the union, which I'd agree with you on, the legitimate activities condition, don't forget, only relates to activities within the union, and it doesn't include disclosure outside the union. So that as a disclosure to an insurer will be disclosure to another body, you'd need to get explicit consent for that. And again, as I said, health as well as trade union membership is a special category of data, so you need to take extra care in relation to health records and anything dealing with a person's medical information.
And we've also had another question which is about mapping in workplaces, and I just wondered if you have any views on that. I know certainly the TEC's been looking at such issues, or
I would suggest that's another area where you'd want to look at your union's policy.
I suspect most unions, as part of their organising departments, are developing policies about mapping, and it's probably a good idea if you are an organiser or involved in workplace organising and recruitment to check in with your union's organising department to find out what the policy is in relation to that. Then we have another question, which is, one question is there going to be a data protection commissioner to ensure that organisations comply with the rules? I don't know if you can tell us a bit more about the...
Yes, so the Information Commissioner, who previously was the regulatory body for the Data Protection Act, will continue that role under the new GDPR, and the Information Commissioner's powers will be strengthened. For example, they will have powers to make increased fines of organisations who breach data protection, and they'll retain the ability to consider complaints in the same way that they have it at the moment. So yes, the body to look for enforcing compliance is the Information Commissioner's Office.
That's really helpful. I think we may possibly have covered most of the questions that have been asked. Just asking my colleague here who's flipping through the questions. I think we probably did cover most questions, unless there are any last burning questions anybody still watching wants to ask. Okay, there is one last question we'll look at, which is how does data protection rules of the new GDPR, how does this affect the use of cloud storage linked between reps and branch officials?
Well, with all these new digital world services, it's important to make sure that the agreements between the person providing the service and the owner of the data are secure enough, and well, they're in place and are secure enough to ensure the sorts of protections which mean effectively that they're as secure as being held by the original owner of the data. That's
great, thank you, Emma. Can I just also say, before you talk and tell people about what the next session is going to be in this series of webinars on the TUC. I just want to say thank you so much for giving us a good taster and a good introduction into how the GDPR might affect reps in the workplace. And just also to make it clear to reps and any union officials watching in, the TUC is developing course materials as part of our stage 1 reps course, looking at the GDPR, ensuring that all reps can get up to speed with the basics that they need to know about the GDPR, as well as working with unions to help them develop their policies. But do tell us, Emma, about what the next webinar is going to be.
Yes, the details of the next webinar are up on the next slide. It's on the gender pay gap. More information and a date to follow. Hope you can join us.
Thank you.